It's very satisfying to help people. I just can't imagine a better job.
Good afternoon, everyone, and thank you for joining. I'm Michael Ettinger from Ettinger Law Firm. This is the fifth in our series of 6 Zoom site chats, and today we're going to be going over selected topics in estate planning. For those of you who don't know me, I'm the principal of Ettinger Law Firm. Our practice is limited to elder law estate planning, and we've been doing this since 1991, so over 30 years now. I'm the author of the book Elder Law Estate Planning, and the slides we're about to see, you did get a copy of them in the confirmation for the Zoom site chat. So you have these slides, but for today you can just follow along with me. Bottom of your screen, there's a Q&A button. If you have a question, click on that, type your question, and we'll answer all the questions at the end. So thank you for joining, and let's go ahead to the slides. Today we're doing selected estate planning topics. We're going to talk about second marriage planning, planning for people who do not have their own children, planning for adult, dependent, and special needs children. Here's the staff at Ettinger Law Firm. So in the middle of the screen, there I am, my lovely wife and law partner, Suzanne Ettinger, to my left facing the screen. The rest of our staff of 8 attorneys and paralegals are here. Ettinger Law Firm, our practice is limited to trusts and estates, wills and probate, estate tax saving strategies, Medicaid applications, and Medicaid trust. We have offices in Nassau County, in Rockville Center, and Lake Success, where I am today in Lake Success. In Suffolk County, we have 3 offices, Melville, Huntington, and Bohemia. Brooklyn, we're in Cadman Plaza, downtown. Staten Island, 900 South Avenue. The Cotra Buildings, near the Hilton Garden Inn. Westchester, 140 Grand Street. Rockland, we just moved from Nyack to New City to 345 North Main Street. Orange County, we're in Middletown. Dutchess County, we're in Fishkill and Rhinebeck. Albany, we're on Wolf Road. And in Saratoga, we're on Broadway. Let's get started. If you just joined us, if you have a question at the bottom of your screen, type the questions. We'll answer all the questions at the end. And we're going to start today with second marriage planning. And there you go, just married again. So second marriage planning is a potential minefield. People come into my office all the time and they're on a second marriage and they come in with what they worked out as a plan. And in just a few moments, I'll say, well, this doesn't work because of this and that doesn't work because of that. And by the way, did you know you could do this and you could do that? And, very quickly, the whole thing changes around. The better approach, I think, is to come to the experienced estate planning lawyer, get your ideas and options, and then go home and talk about it when you know what you're talking about. So what you really want to know is what other people do and why they do it and what your options are. So one of the problems with second marriage planning is one of the spouses or both of them have children from previous marriage. Sometimes they have one or both of them have children from previous marriage and they have children together. We call that his, hers, and theirs. So how are you going to plan in a minefield like this? The key to look at it from an overarching perspective is the plan should not only be fair, but seen to be fair. People get their nose out of joint if they think they've been left out or unfairly treated. So it has to appear to be fair as well as be fair. So what are the issues? Well, the first issue is what's going to happen after the first spouse dies. Obviously, it could be the husband or the wife, but more often it's the husband. So in this case, we'll talk about the husband, but it applies equally if the wife dies first. So what if husband dies first? Well, do all the assets go to the surviving spouse? In that case, his children from previous marriage are going to be very concerned they'll ever see any inheritance from their father. What about the house? How are we going to deal with the house? Does she get the house outright? Does she have the right to live there? For how long? If she has the right to live there, does she have the right to substitute the property? Can she take the house, sell it, and buy a condo? That sort of thing. Can she take the house, sell it, invest the money, and take the income so she has money for rental? She doesn't want to be an owner anymore. So if we have the surviving spouse act alone, there's nothing to stop him or her from diverting all the assets to their children, especially if they get older and dotty and they don't have an ongoing relationship with husband's children. By the time she gets to the end of the day, she may have forgotten all about his children, or due to dementia, other reasons they get left out, or her children have convinced her they haven't been good to her and they don't care about her. All kinds of things happen. You know what I'm getting at. And even the best intentioned people can be influenced later in life and or lose cognitive ability. So people say, oh, I trust my wife, I trust my husband. Well, you may trust that person that you see in front of you now, but you trust what they're going to become and who they're going to become. And do you trust the person who's lost some or all of their cognitive ability? Of course not. That's the nature of the problem. So the children of the first marriage feel very vulnerable, unprotected, exposed. And this doesn't make for a good relationship between them and the surviving wife, does it? They're going to be fearful, suspectful, a little paranoid maybe. And they could end up being hostile to her. And what if she remarries? They're going to be even more further removed. And maybe they never liked her, but they put up with her because of the father, or vice versa. So all these issues come into play. So how do we solve this conundrum? And now we go back, before I get into it, back in law school, which is over 40 years ago for me. I remember my trust law professor. One of the things he says is, you'd be surprised how fast the family glue comes undone. So you can't just rely on the family glue. You need some legal protection. So you put in a co-trustee. Well, what if you put in husband's daughter as the trustee with his second wife? Look at the picture, okay? It tells you all you need to know, okay? You have a real problem, because this daughter, who's the daughter of the deceased husband, any money she spends on her stepmother comes out of her inheritance. She's got an inherent conflict in terms of what she wants to do for the stepmother. And the stepmother is going to be very uncomfortable asking her stepdaughter for funds. This is where the estate planning attorney comes in. Sometimes what a client will do is say, okay, if I die, I want my lawyer, Michael Ettinger, or whoever it is, to be co-trustee with my wife. Now, the children know that the terms of the trust are going to be protected because dad's lawyer is co-trustee with mom. He's an impartial arbitrator. They'll feel secure. They have skin in the game. They have a lawyer representing their interests. We protect the principal for the heirs, so she can't just go out, wife number two, and spend everything to her heart's content. There's obligations to preserve the estate for the heirs, so she has to stay within certain guidelines, one of which is the prudent investor rule, to make sure the money is invested as a prudent investor would, handling their own affairs, so conservative investments. We also have to make sure the trust fund grows to offset the effects of inflation. So there's a two-pronged investment strategy: partly invest for growth to offset inflation, partly invest for income to support the surviving spouse. If she needs or wants to do something, she comes and talks to her own lawyer. She has privacy. She doesn't have to go to his children or her children. Okay. So when everybody's secure and their interests are protected, now the relationship can keep going and growing. So there's a lot of issues in second marriage planning. I'm just scratching the surface here, especially the house and the right to substitute the house for a condo, that sort of thing. We pioneered some of these techniques here at Ettinger Law Firm, and we want to know what works, what other people do and why they do it, then go home and talk about it and make your decisions. But talk to an experienced estate planning lawyer. Make sure you have a second marriage plan that works. Our job here today is to raise the issues, get you thinking, but we're not necessarily going to solve the problems here today. Again, if you just joined us, there's a Q&A button at the bottom of your screen. If you have a question, type it in. We'll do all the questions at the end. What about the IRA? Now, the IRA is a special case because a lot of people have significant, if not the majority of their assets in IRAs. So if you name the IRA, you leave the IRA to your spouse, which you want to make sure he or she has enough to live on. So the beneficiary of the IRA, who are they going to name as beneficiary? Their children. So now, how do you make sure that whatever they don't spend gets back to your children? I mean, you want to take care of your surviving spouse, in this case, the wife, but you don't necessarily want to take care of her children. So here we use a contract. It's called an IRA contract. We created this at Ettinger Law Firm. And what husband says to wife, I promise you to leave you my IRA, provided you promise to designate my children as the beneficiaries on your death. Okay. Now, so when she dies, it'll go, whatever she didn't spend goes back to his kids. But what's to prevent her from taking all the money out of the IRA, paying the taxes, and giving it to her kids? Because we put in the IRA contract that withdrawals that are made in excess of the required minimum distribution can only be consent on the lawyer acting as trustee. So she gets the required minimum distributions. If she needs more, the lawyer has to sign off. So she can't raid the IRA, take it all out and give it to her children. Not that she would, but later on, people get old and dotty. The kids see that the late husband's wife, the late husband's kids are the beneficiary. He might have died 20 years ago. They say, well, look, it's your money. He meant for you to have it. To change the beneficiaries to us. They won't be able to do that. Let's move on to the second topic: planning for those without children, planning for disability. So we meet a lot of people who don't have children. And you could be single or a couple, but the big issue for people who don't have children is not who gets it after you're gone. The big issue is who's going to take care of you if you become disabled. And you want somebody who's going to take care of you well and properly. So that's your big issue. To whoever's getting the inheritance is usually a windfall because they're not the children, so they have no expectation. Could be nieces and nephews you're very close to. I'm not discounting that. Some people have nieces and nephews they're almost as close to, if not as close to, as children. So to those people, it's not a windfall. It's a genuine loss. But many times, the inheritance is a windfall. It's found money. They weren't expecting it. So in the case of people who don't have children, naturally, they come first. If you don't have children, you come first. Who gets it after you're gone comes second. And the key question is, who do you want to take over if you become disabled? And you have to get somebody who cares about you and knows what to do. You want to set up a plan so you don't end up with a legal guardianship. So the first thing is, if you don't have a plan for disability, you get the state's plan, which is you can't handle your affairs. Either your doctor reports it to the Department of Social Services or the nursing facility. Social worker, doctor, any friend, financial advisor, lawyer, anybody who sees you're being taken advantage of, you can't handle your affairs, they can start a guardianship proceeding where the state appoints a stranger to handle your affairs. We don't want that. We want the people we have chosen. So we want to set up a trust in this case, appoint our successor trustee. Can be one person, can be two people, act together. So, two heads are better than one. But this way, if you have a trust, the judge cannot cancel a trust. A trust overrides a guardianship, and if you become disabled, the successor trustees that you name take over. You don't have a stranger in charge of your affairs. You have your hand-picked people, and if you want extra protection, you can pick two people, require them to act together, so they watch each other as well as you. So who's going to be the trustee to take over? It could be a friend, a relative. It could be your lawyer. It could be a friend and the lawyer. I want two people if it's me. That's more protection for me. As we said, two heads are better than one. Two heads also avoids mistakes. One person makes a mistake, the other person catches it. It prevents stealing. That's a malfeasance. And it prevents a third party interfering. You might have picked Joe, but his wife is bossing him around, and actually the wife is making the decisions, and you didn't even know about it. So with two people involved, you avoid that third party interference. So let's go back. So without children, disability planning is everything. Who's going to take over if you become disabled? What's their plan for handling your affairs? You can talk to them and say, how would you handle it? What would you do? Here at Ettinger Law Firm, when we have a client we take over, if they become disabled, they've chosen us, we hire a geriatric care manager. A geriatric care manager, you can look it up. It's a professional designation, a GCM, geriatric care manager. usually a retired nurse or social worker. I myself prefer retired nurses. They hire the caregivers, they supervise them, they supervise your medication, they supervise your physical environment, and what you're eating, your diet. Does your bed or any of your furniture need modification? Does your living arrangement need modification for your disability? And they prepare a report to the lawyer every week, and we keep an eye on what's going on. So we have eyes and ears on the ground. So let's move on to protecting assets for dependent adult children. Who are we talking about? Well, there's the spendthrift on the left, and on the right, the kid with a sense of entitlement who nobody could reason with. So how are we going to deal with these? A lot of people have adult dependent children. They could be, well, we saw the spendthrift and then this one with the sense of entitlement, but there's also ones with substance abuse problems, alcohol problems. They could be learning disabled, special needs, emotional issues. So generally, for whatever reason, maybe not successful in life, immature, or the entitlement mentality. They could be not good. They could be mature, but just terrible at handling money. They could have alcohol or substance abuse issues, learning disabled, special needs. So how are we going to protect them? Well, you have to put their money in a trust and name somebody as the trustee. It could be the child and another family member. It could be, you could require them to act together. It could be the child and your estate planning lawyer. It could be just the other family member and the lawyer, not the child, because they can't really be a co-trustee. So that depends on the nature and extent of their issues. Can they be one of the trustees, or do you need other people? It could be the lawyer acting alone. A lot of people don't have another family member. And you don't necessarily want to reach out to remote relatives, a nephew or a cousin you hardly ever see, and say, hey, would you be the trustee for my trust and my wayward son? It's a big responsibility. There's liability, there's fiduciary duties. It's not something you ask somebody lightly. And, very often people, when you ask them, people don't like to say no. So they say yes. And then when they get involved and they see what they said yes to, they quickly want to get out. So you need somebody who knows what they're getting into as well. Now, if you put in a trust, there's different ways to let's go back. You could say it stays in trust for their lifetime. They get the income for life, whatever they need, that sort of thing. Or you could have it pay out over a period of years. You could say, well, give them 20% of what I left at age 30, one half of the balance at 35, and the rest at 40. You could say, give them 20% on my death, one half 5 years after I die, the remainder after 10 years. This formula was designed on the theory that people get to 20%, they'll blow it, but to have to wait 5 years before they get the next half. And finally, 10 years later, and have some smarts, half the estate is still left. So it gives them a chance to make some mistakes and not burn through the whole estate. What about special needs children? Special needs children, they are receiving SSI and Medicaid. If you lose your SSI, you lose Medicaid. So you may want to provide for benefits that Medicaid and SSI won't provide, which we'll get to in a moment. But with these trusts that only pay over and above what the government pays, they don't disqualify them from SSI or Medicaid. You can't pay the child directly. Basically, you pay their bills. You have to make sure that grandchildren don't leave things to their grandkids, or brothers and sisters don't leave anything to them. Well-meaning, but of course, they'll knock them off the SSI and Medicaid. Here, we're talking about two kinds of trust. There's this first-party trust and the third-party trust. Third-party trust is left by a third party. So mom, dad, grandma, grandpa, if they set up a trust for a disabled child, that trust can take care of the disabled child for their extra needs, and whatever isn't spent goes back to the family. A first-party special needs trust is done with the disabled child's own money. They might have gotten an inheritance. They might have had a personal injury award. First-party money, if you get money, the disabled person, you can put it in a trust and protect it from SSI and Medicaid. But whatever you didn't spend when the child dies has to be paid back. There's a payback provision because the theory is it's your money, a disabled person. We want you to be able to get what you need during your lifetime. But after you die, it's clear you didn't need any of that, the rest of that money, so it should go back to pay what the state paid for you. So first-party trust, their own money, from personal injury or an inheritance, that has a payback provision if there's anything left in the trust when they die. Third-party trust set up by a third party, like a parent or grandparent, with their own money, no payback provision. If there's anything left in the trust, it goes to their brothers and sisters. So we want to avoid overcompensating. So when dealing with parents with special needs children, I like to use the expression, the tongue always turns to the aching tooth. Because they have a disabled child, they're focusing all their care and attention to the disabled child, and they're not looking out for the interests necessarily of their other children who don't have these problems. So we want to avoid overcompensating, giving an unfair distribution. We want to make sure everybody's treated fairly so that we don't have social problems with the other family members who are the primary caregivers after mom and dad die. So we don't want them to resent their brother or sister for getting the majority or all of the estate because they were disabled. It doesn't have to be equal. People generally have a tendency to leave it equally, but I'll ask the client, well, how much are you spending on a disabled child now? Are they covered 100% by government benefits? You're just taking them out to dinner for once in a while. You don't have to leave $1 million in trust for that. So we'll look at your family, your assets, see what's the right amount to leave for the disabled child to meet their needs for the balance of their lifetime. You may want to consider something called second to die insurance. So you take out a policy, if you have two parents, it's on both their lives, and it pays when the second one dies. This is less expensive, naturally, because the insurance company doesn't have to pay until 2 deaths. But it's on the second death when the money is needed. So this insurance could fund the special needs trust, so you don't have to take out of the pockets of the other children. We suggest you write a letter of intent. A letter of intent is to the person who's going to be taking care of a disabled child. What are their daily medical needs? What are their routines? What are their likes and dislikes? Put somebody in the picture so they're better able to handle that particular person's needs and desires. What are their hot buttons? That sort of thing. What does the special needs trust pay above that the state pays? Well, some clothing, essential dietary needs, education, hobbies, sports, exercise, tickets for events, health costs, and not routine, but perhaps elective medical procedures, vocational rehab, household goods, appliance, furniture, computer, television, personal care products, personal services. If the trust owns property, taking care of the house, music, real estate. Obviously, the state is not going to provide real estate, but you can leave them a place to live, a car, transportation, vacations, burial costs. These are all over and above what SSI and Medicaid would pay. A word about estate planning for larger estates. I like to throw this in because people don't know. New York has an estate tax, starts around $6 million. So if you're under $6 million, the vast majority of people, not a problem. But over $6 million, all of a sudden you owe over $500,000 in estate taxes to New York. I want you to know, if you have a spouse and you set up 2 trusts, one for the husband, one for the wife, you can double the estate tax exemption from $6 million to $12 million. How much you save? You save at $500,000 and $6 million. It goes up to over $1 million when you're at double that. So word to the wise. You may, if you read my column or you read my newsletter, you will know that Biden is proposing to reduce the exemption to $3.5 million, and that'll be a 45% to 65% tax on the amount over. So if you think you're going to be over $3.5 million, you're already over. Get in to see an estate planning lawyer pronto to make sure you don't end up with a big estate tax bill at the end of the day. Tomorrow, I present my weekly seminar, 4 Advantages of Using Trust. It's every Wednesday at 2. You register at ettingerplan.com, and you'll get the slides, and you'll get the Zoom invitation. Even if you can't make it tomorrow at 2, if you register, you get the recording. You can watch it later. At that seminar, I give it once a week. I've been giving it for 30 years. I'll talk about the 4 advantages of using trust, which are: they avoid guardianship, they avoid probate, to keep your assets in the bloodline, and to protect your assets from long-term care and nursing home costs. I go into each of those in detail. I think you'll find it very valuable, and you can get that and share the recording with your friends and family. Also, when you register at ettingerplan.com, you get my 4-color booklet, Elder Law Estate Planning in a Nutshell. It comes by email, very easy to read. and everything you need to know. Wednesdays too. We have a unique planning process. It's begun with this seminar. We offer a free consultation where we review your existing plan. You bring your will, trust, power of attorney, whatnot. We give you a free copy of my book, Elder Law Estate Plan, and tell you which chapters apply to your situation. Again, when reviewing your existing plan, not just looking at whether it's legally sufficient, is it personally sufficient? Are these still the people you want in charge? Is this still the way you want it distributed and who you want it distributed to? We tell you at the first meeting, if you decide to go ahead, we have a fee schedule. This is how much it will cost. And we invite you to a second follow-up consultation to have your questions answered. And you come in for your second meeting. We answer any questions you have about the chapters in the book we asked you to read, about what we discussed at the first meeting. We draft the estate plan together with you. Get all your questions, who do you want to make medical decisions, legal decisions? How do you want to distribute it all at once over time, equal, unequal? Make some suggestions. And then we give you a detailed 3-page written proposal of fees quoted. Now, the fees we mentioned, if you recall, in the first meeting, but now it's in writing. What would you like to do? It's up to you. And if you decide to go ahead, we don't have a retainer agreement here. I think we're the only firm in the country that doesn't use this for estate planning. That's where you sign the retainer and you give the lawyer a check for half the funds. We don't do that. We prefer that you be satisfied before you pay anything. So we say, hold off. No fees are due until after everything is signed. You come in for the third meeting, review the trust, inheritance trust, health proxy, living will, power of attorney. After everything is signed, you pay at the end. But unless and until you write us a check or you hand us your credit card, you have no obligation. You're free to walk away. We like to keep our clients in control. It's the best place for them to be. And if we're here to serve you and that's the best place for you to be, we believe it's the best place for us to be. We accept credit cards. You can pay it all at once or in 3 monthly installments, or you can pay by check. After you sign with us, we don't say goodbye. We say welcome to the firm. We have a trademark process. Keep you up to date of law changes and other matters for our weekly Ettinger Elder alert. It says that because it comes by email. And review it every 3 years. Send you a letter. Time to come in for a free review. See if there's any changes in your health, your assets, your family, births, deaths, marriage, divorces. People coming after 3 years, not too many people need to change, but we catch up, renew the acquaintance. But, eventually 9, 12 years, most people need to change, who's in charge, who they're leaving to, something else happened. You do an amendment, that's legal work. You pay for the amendment when you need it. But, maybe once every 10 years you pay, still hundreds, not thousands. Point is, when you go to use that Ettinger plan, it's never more than 3 years old, designed to work when you need it, not when you wrote it. Here we don't charge for phone calls, emails, or questions. You can call and get your questions answered. So by using this program, as I say, your plan is never more than 3 years old, designed to work when you need it, not when you signed it. A free consultation will be with myself or my wife, Suzanne, or one of our other experienced elder law planning attorneys. A lot of firms charge for it, so we say it's a $500 value. It's probably worth more than that to a lot of people, but we don't charge it. So you get a free $500 value. You'll get a link after this Zoom. You'll get a copy of the Zoom, but you'll also get a copy of our link. You can go into our calendar and make your own appointment. You call my director of client relations for more than 26 years, Patty Brown. She's at the 800 number, or email her, pattybrown@trustlaw.com. She can answer any question you have. She's been here a long time. So that's good. We're going to stop this share, and let's go to the questions we have for today. William B., he's a regular. Hi, William. How is income from the trust taxed after it goes to the heirs? Well, first of all, it doesn't get taxed after it goes to the heirs. If it goes to the heirs, it gets taxed to the heirs. So any income on a trust that's paid out is taxed to the individual at their individual rate. Any income that's retained in the trust gets taxed at the trust rate, which of course is the highest tax rate. So to reduce the taxes, you pay the income out to the beneficiary, and they pick it up on their individual return and tax. The trust doesn't pay the tax. Anonymous. Can an aunt set up a special needs trust for her niece? You can set up a testamentary trust. You can leave it to a special needs trust after you're gone. So that's a possibility. Not a current one to put money in now, but you can leave an inheritance and a special needs trust for your niece. Yes. William B says, you said if I have several classic cars, I can retitle them to the trust. That's true. How does that impact liability to the trust assets auto insurance? Well, if you have an accident with one of the cars, the trust assets are liable. So you want to make sure you have enough insurance and an umbrella, or leave them out of the trust, and we'll probate those assets. Paulette says, if there will be a large inheritance in a special needs trust, how do you avoid a large income bill annually? Well, what you do there, it appears that funds can only be used to purchase things for disabled child. There you go. That's correct, Paulette. But you can invest in triple tax-free municipal bonds, so there's no tax. You could purchase annuities, which the tax is deferred until you take the money out. So there's a couple ideas there. Joseph F. says, if there's a situation, is there a situation where a judge can turn over a trust? It has never happened. A judge cannot overturn a trust. No, it does not happen. Sometimes they have the right to modify a trust if it's impossible to carry out. Joseph F. In the case of having children, how many trustees is recommended? Well, it depends. Depends how many children you have, where they live. If you have 3 children, 3 is a little unwieldy as the number of trustees. You might pick one of them, and the backup is the other 2 together if something happens to the one. If you have 4 children or 5, I usually say pick 2, because then the others will be secure. With 2 of the kids involved, their interests are protected. Anonymous, can you get a double protection if you put a rental property which is already in the trust to an LLC? If it's already in the trust, you can't put in an LLC. You have to take it out of the trust, put in the LLC, and then put the LLC interest into the trust. Dave M. says, if no kids, is power of attorney and health proxy sufficient in lieu of a trust? Well, heavens no. Power of attorney allows somebody to handle your legal and financial affairs. Health proxy allows somebody to make medical decisions, but none of them will say where your assets go after you're gone. So you need a trust to avoid probate, avoid a will contest, and get the assets of people who you want. By the way, a power of attorney can be overturned by a court, and they can appoint a legal guardian. That's why we like trust, Dave, because they can cancel your power of attorney and put in a legal guardian, but they can't cancel your trust and put in a legal guardian. So if you have a trust, it guarantees you get the person you pick. Dave says, and the will, of course. Oh, well, there he is. He's with the will. But I like the trust because the trust will defeat a guardianship and avoid a probate. Lorraine P., there is a property now in a trust my mom set up. Okay, she has passed. Would there be a 5-year look back on the property? So the property's now in a trust your mom set up. She died. Is there a 5-year look back? Well, I have to look at the trust. I'm not sure what it says. I have to bring it in and we'll have to look it over. So thank you for joining me today. I hope that you'll be able to join me tomorrow for if you haven't seen it, 4 advantages of using trust. Next week, same time, Tuesday at 2 o'clock, we're going to do the 10 reasons why you want to have an estate plan. So thank you for joining. Stay safe, everybody. Hope to see you all very soon here at Ettinger Law Firm. Have a good afternoon.